Hello and welcome to episode 102 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director.
I'm Joanna Baron, the CCF's executive director. And in today's episode, I'll tell you about a debate that I participated in with Toronto Councillor Brad Bradford on bubble zones and what we have heard so far about the impending federal liberal bubble zone legislation.
And I'm going to talk about my brand new children's book, Maple's Garden, available on Amazon, which is about the importance of the right to freedom of expression and why it's a value we all need to teach our children.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, Parliament is back, and I'll be digging into the details of this Stronger Borders bill, which is a mammoth piece of legislation that raises many civil liberties concerns. So we talked about this bill a little bit back in June when it was first dropped by the Liberals. It's called C2. So they dropped it and then they pieced out of Ottawa for the summer, giving us all a bit of time to, more closely examine this huge piece of legislation. And, rumor has it, a lot of people are saying that the Liberals rushed this out back in June because they were trying to appease the Trump administration's concerns about border security. Remember that? In order to try and get this comprehensive trade and security deal that they said they were going to sign, but that never actually happened. So I think the rush job is becoming increasingly apparent here. As we said at the time, there's lots of good stuff in this bill. For example, it makes it harder for people who have been in the country on student visas or work visas to suddenly claim asylum if the country tries to send them back. But our concerns are many, and they've only grown over the summer. So I'm going to walk through a few of those today and tell you a bit about what the various parties are saying about this in debate in the House of Commons. So probably the most interesting thing that's emerged from this bill over the summer is something that I totally missed the first time, but that law professor Robert Diab of Thompson Rivers has talked about in a new paper, and that's that the bill would give not only so-called lawful access to police and CSIS, so not only the ability for them to, go to Gmail or WhatsApp or any other electronic service provider and install devices to lawfully access certain information, but it would also give the minister the power to secretly require them to create backdoors into encryption done through regulations, and then the companies that were affected would not be allowed to speak publicly about this happening. And the concern with the back door is that it could allow huge, massive scale surveillance, including real-time surveillance without a warrant, which is the usual requirement under Section 8 of the Charter. And obviously that creates huge civil liberties concerns. It's the possibility of the surveillance state that we all worry about. So it looks like the government isn't really sure whether they want to do the back door or not by the way that the bill is written, but according to Diab, it does give them this option. So Diab was writing about this and how it's been something that the Five Eyes group has been talking about. But Australia went the other way. They said, no, we're definitely not going to allow backdoors. That's what their legislation says. Britain, of course, being the surveillance state that it is, said that they are going to allow backdoors. And this famously started a big fight with the US administration. So Britain had said that Apple iCloud needed to give them a backdoor through encryption. And Tulsi Gabbard, the US Director of National Intelligence, pushed back, and the UK relented and said, okay, no backdoor. I think at a minimum, something this important needs some debate in Parliament, in the House of Commons. I mean, can you imagine what they might have done with this power during the Freedom Convoy? So interestingly, this wasn't a huge topic of debate yesterday in Parliament, but it was brought up by Conservative MP Rhonda Kirkland from Oshawa, who said, encryption ensures that people have safe lines of communication online when they need them. For survivors of intimate partner violence, encryption is a lifeline that secures confidential information about escape plans and protects victims, including children, from abusers. So this is a bit of an odd example, but I'm glad to see that it's at least being brought up in Parliament. Okay, a second part of this bill that's gotten a lot of attention is Part 11, which would ban most businesses and charities from accepting more than $10,000 in cash, including in smaller increments over a series of transactions. And our position is, paying for items in cash is inherently more private than paying for items electronically. So we should always be concerned when the government starts talking about cash, especially considering it could become a slippery slope to smaller and smaller amounts of cash being banned and more surveillance of what we're spending our money on. This was something that a conservative MP named Cheryl Gallant hammered the Liberals about. And she said very clearly that the Conservatives are going to oppose this part of the bill. So Gallant said this is not a targeted measure against money laundering. It's a blanket restriction that affects law-abiding citizens. It treats legitimate transactions as suspicious simply because they involve physical currency. It forces Canadians into digital payment systems that are traceable, surveilled, controlled, and hackable. Using cash is not a crime. It's a form of legal payment. It's a tool for privacy, autonomy, and financial freedom. Criminalizing its use sets out a dangerous precedent. Today it's 10,000, tomorrow it could be 5,000, then 1,000, and eventually nothing. This is a slippery slope towards a cashless society where every transaction is monitored and every citizen is tracked. So, very interesting words there. Third aspect of the bill that raises privacy concerns is Part 4, which would allow Canada Post to open your letter mail rather than just parcels, which they can already open. And they can do this if there's reasonable grounds to suspect that it contains dangerous goods or contraband. And our position is that, well, this may be necessary to reduce the amount of fentanyl that's harming Canadians. There have to be some safeguards here to make sure Canada Post isn't reading your mail. For example, the act could restrict employees to only opening mail under video surveillance and then require that a copy of that be sent to the person whose mail is open so they can check that nobody's reading their mail. Oddly enough, I don't think the Liberals even understand their own law here because in response to Conservative questioning about this, Parliamentary Secretary Kevin Lamoureux said that if a drug dealer puts fentanyl in an envelope, this would allow through a warrant for that envelope to be opened. And that's not quite right here because while it does say police would still need a warrant to open the letter mail, Canada Post employees would not. They would just require that reasonable suspicion. So there's probably many easy solutions here to fix this law. For example, they might need to call RCMP before they open a letter every time. They might try and get a warrant, but the way that this law is written right now doesn't make a lot of sense. And we know this because we attended a session about this with DOJ lawyers, and they couldn't even answer my questions about this particular aspect of the bill. So next up on our list of concerns is the warrantless information demands. And this is part of the bill that would allow police officers or other agents of the government to demand that anyone who provides services to the public, so that's a very broad group of people, pretty much everyone, to hand over subscriber information of the following type. So whether a person provides services to a particular person or account, dates when they've provided services, the province, country, or municipality where they provided those services, and whether the person is in possession of other information related to those services. So obviously this is not a huge amount of information, and if they want more, they would need to get a warrant, but this is still information that we have a reasonable expectation of privacy in. It's still information that deserves safeguards, and I just don't understand why police can't get a warrant for this type of information before going any further. For example, the definition of service provider is so broad it could let police demand to know whether a doctor has treated a person. It's pretty private information. Whether a particular person is on a dating app, whether a particular person has donated to a cause on GoFundMe. These are all things we might want to keep private, and the service provider here would face a $5,000 fine if they don't just hand over the information. So I don't understand why we can't just continue to require warrants, a bare minimum, one page, here are the reasons why I suspect there's a crime, and, judge, can I have this Can I have this warrant to search these people? I don't get why we can't just have that minimum standard. On these warrantless information demands, it was really Jenny Kwan of the NDP who went hard against this. And she said, this includes doctors, banks, landlords, schools, even psychiatrists. The list goes on. Let that sink in. Um, and yeah, I totally agree with MP Kwan here. So there are a couple other concerns in this bill. There's just so much that affects privacy. I won't get into it all. Um, and I will say, to be fair to the Liberals, they did offer a response here, which is that, these are serious issues: money laundering, fentanyl, terrorism, and we need to combat those things better than we're doing now. I don't think anybody disagrees with that. But I did want to point out one thing that Julie Dzerowitz, who's the MP on this file, said for the Liberals. She said, quote, "Bill C2 clarifies the ability of law enforcement to use specific powers and seize specific information without a warrant in urgent, time-sensitive circumstances, such as if there's a live and active abuse of the child." But this is such a red herring because there's not one civil liberties group out there that has opposed these particular exigent circumstances provisions, as far as I know. So, you know, all these MPs from the Conservatives and NDP are bringing up real concerns, and the government's response is, would somebody please think of the children? Joanna, does that remind you of any other bills that the Liberals have put forward in the distant past?
Yeah, well, major deja vu to online harms bill C-63, which of course was presented by Arif Virani as the only way to crack down on online child sexual exploitation. And if the bill actually was about that, then it would have had pretty much universal support. But instead, as we know, it was a Trojan horse for a sweeping online speech regime that would have permitted massive regulation of all online speech. And the sales pitch was, and the refrain was, we have to protect kids from predators. And when I testified at committee about this, I even got some questions specifically about like trans kids and gender diverse kids, when really you're talking about broad speech control. And now with Bill C2, it's the same, tired rhetorical move. So we need the power to open all Canadians' mail because of fentanyl killing kids. We need back doors into encrypted messaging to stop child exploitation. We need warrantless information demands to protect children from abuse. And I think, as you've really clearly gone through, these provisions are not narrowly drafted for child protection cases. They're open-ended powers that would apply in all kinds of investigations with minimal oversight. And we know from long past experience that once you create surveillance infrastructure, it doesn't stay confined to the sympathetic purpose that you use to sell it. So we're watching this bill very carefully. We put out a statement about it yesterday. Anything you want to add, Christine, before you tell us about lighter things?
Yeah, so I would say that this connects really well to this report that I just did on safetyism. This whole idea that, some mail might contain fentanyl, so we need the power to search all mail that is, in this bill. It's safetyism. I did this report. You can download it for free at the TheCCF.ca/safetyism. It's this idea that we need to prioritize physical and even emotional safety above all other values like privacy, freedom of expression, personal development. Everything needs to be sort of serving the goal of safety. And, safety is important, of course, but governments tend to exploit the concern and fear that Canadians have about their safety to grab all kinds of new powers at the expense of our right. They use it to justify, in this case, surveillance, but all kinds of other things like censorship or restricting basic freedoms like entering the forest, for example. or preventing people from just even being offended, as we know from some of the other challenges we've had to, for example, bubble zone laws or anti-bullying laws in Waterloo. So you can download that report where I kind of delve into this and I look at some of the worst examples in Canadian history, because while this bill is bad, it is not, it's not in the top 10 of the worst safetyism things we've seen, but, we'll have to see how it's actually implemented if it passes in this form. But, the government uses this rationale of safety to do some of the most atrocious things we've ever seen. For example, the internment of Japanese Canadians, the invocation of the Emergencies Act. Really, really, you cannot let the government use this excuse. This is all to keep you safe, because they will do it to end up oppressing you. Let me turn now to, yes, a lighter topic. It's something I've been working on for about a year now, and I'm finally ready to announce it because this has been waiting for a while, and I'm so excited. It is this new children's book that I have written about freedom of expression. It's called Maple's Garden. If you're watching online, you should be able to see it, although I think it might be reversed. So we might have to flip the image. Okay, this should be fine. Okay, so it's a book about a little girl named Maple. She's a nature-loving girl who has a wild and pollinator-friendly garden at her home. And her garden is threatened by city laws, a snoopy neighbor, and a meddling mayor. And she discovers her voice to stand up for herself and the Canadian Charter of Rights and Freedoms. So her garden is how she expresses herself and her beliefs about nature. It's also on her own property. And we all get to decide for ourselves what we like, what we think is beautiful. So in this book, it's a story about how a snoopy neighbor and this meddling mayor try to have her garden cut down because they don't like it. And Maple learns how the Charter guarantees the right to freedom of expression, that rights are things that we all have because we are born with them as human beings, and that we can all have different opinions, and the government doesn't get to decide which opinion is right. And if they try to, you can go to court. And that's exactly what Maple does in this book. It's actually based on a number of real cases, including cases that we worked on at the CCF. So at the back of the book, there's actually a explainer page for parents about the cases that this book is based on. So it's in part based on a case of Sandy Bell from Toronto. The case is called Bell and Toronto, and she sued the city over a bylaw that prohibited excessive weeds, which they used to try to enforce against her garden, her naturalized garden. It's also based on the case of Ruck and Mississauga, a case we worked on this year where the city of Mississauga tried to set standards for beauty on private gardens, at private homes, and they tried to enforce against Mr. Ruck's naturalized garden, which they in fact did raise his garden to the ground several times. It's also based on part on multiple cases from across Canada where city councils have attempted to restrict signs in public meetings. And while many of these laws are still in force at the municipal level, they're likely unconstitutional. And we at the CCF have actually warned cities about these laws, and we are litigating over one of them in Niagara Falls, in Niagara Falls. There's existing case law about this, including a case called GAMI and Town of South Bruce Peninsula. So it's also based on cases about prohibitions on postering, like Ramsden and Peterborough, and on the famous case that we brought, Canadian Constitution Foundation and Frontline Nurses and Canada from 2024, where the federal court held that Cabinet's invocation of the Emergencies Act in response to a protest in downtown Ottawa was illegal. And, there are some great images that sort of capture some of that sort of idea of extreme enforcement against protests. So I wanted to write this book because I think in Canada, our resources for children about the importance of these fundamental freedoms are really lacking. I had purchased a book about basic civics and rights. And one of the lines that just sent me was this line that we have rights because they are given to us by the government. And that's absolutely so wrong on a philosophical level. Our rights are given to us by nature of being human beings. They are guaranteed in constitutional documents. The government does not grant us our rights. The government creates documents and constitutions that enforce the rights that we have as by virtue of being human. So, and I have three children. I know how important it is to explain this to children, to explain these values to children, because they do not pass themselves down. They need to be taught. And I actually think, we're in a really distressing time right now where there seems to be this concept right now that we cannot tolerate, or some people cannot tolerate a difference of opinion. And some people seem to think a difference of opinion needs to be countered with violence, physical violence. And we saw this last week with the horrific murder of Charlie Kirk, which I cannot get out of my mind. It is so upsetting. And this is a person who a lot of our children really knew and looked up to or were very familiar with. And they saw this notion that a person you might disagree with is now deserving of murder. This is horrifying. And I think we really need to talk to our children about tolerating differences in opinion and why we all have a right to use our voice to express what we believe. And look, I understand this can be a hard thing to talk to our kids about. And, I obviously have been working on this book for a year, but this book approaches this difficult conversation about tolerating views that we might not like or we might disagree with in a way that is really gentle and that children can understand. I also wanted to just mention the illustrations of the book really briefly. I worked with a childhood friend of mine to do the illustrations for the book. So she and I went to elementary school together. While I was, researching the book, I found out that a lot of children's books now are illustrated by foreign artists that you would hire on a platform like Fiverr, and they work with AI to generate art, which gives a lot of children's books right now a really sort of uniform aesthetic and look. And it was really important for me to work with a Canadian artist who makes art by hand. And Lisa Ng is the artist, and she's a surrealist painter. So all of her images have this kind of really dynamic look to them because they're hand painted and with this really unique style. And one of the reasons I wanted to work with Lisa is she has had her own experiences with trying to be silenced. So she really understands the project. She had some art that was displayed at a public library, and people complained about her art because they said it was too spooky or something. They said her art was too scary. I mean, not really, but she was exploring different themes. And so this art, people complained about it at the library took it down. And then sort of the most concerning to me was in 2022, Lisa was really interested in the Freedom Convoy. And so she painted an image of the convoy and she posted it online, and people attacked her from the art community, actually. And look, art is where you need to have so much freedom to explore different ideas. And it's absolutely crazy to me that the artistic community would say that there are subjects that are off limits. And it sort of shows how important it is that we have resources like this to teach the next generation. Stop trying to cancel people because they are interested in something that you don't like. So I've been working on this for a year. I am so thrilled that it is finally ready. You can order it on Amazon. Just search for Maple's Garden. It's also going to be available at select Indigo and Chapters locations. Joanna, when I was looking for the artist to work on this, I had Lisa in mind, but out of just doing our due diligence, we did contact some other artists to get comparative quotes. Do you remember what one of the artists told me? Why don't you share that story?
Yeah, well, didn't she say, like, could you clarify what your positions are as an organization on vaccines? That was the thing, right?
And the carbon tax. She said,
Yeah,
"Are you against the carbon tax?" I'm like,
yeah. This is
I
just like
think
a random,
Canada
yeah,
is against the carbon tax now.
yeah,
So
graphic
like,
designer on Fiverr. Yeah, that was creepy. But it's a good reminder that, yeah, we need to build a counterculture because this sends a chill down my spine even to think about it. Think how many parents, after the Charlie Kirk killing, sat down with their kids and said, he was a really hateful guy and he got what was coming
that's
to them.
so scary.
Guaranteed millions of parents, millions of millennial and Gen Z are starting to become parents. So there are kids who are being raised basically with, well, he got what was coming to him. And so we need to build, I mean, I hope it's not the majority, but based on what I see people posting on Instagram, and
Yeah.
many of them are parents, I know a lot of kids got that message in this past
Yeah.
week, which is
Yeah. We need to
extremely,
give a different message that
yeah. What do you think,
speech
Josh?
matters.
Yeah, I think that the millennials are a lost cause. We need to get them young, get them interested in freedom and understanding why their rights matter at a young age. Look, like kids, we don't give them enough credit. They understand a lot of these concepts. Property rights, for example. They understand that it's important that they be able to take ownership of certain things in the classroom, that things are mine and that they're not yours, and that I decide whether I want to share this or not because this is my property. The other thing is that old saying, sticks and stones can break your bones, but words can never hurt you. Well, if you think about free speech and the line between what speech can be limited and what can't, that's pretty close to where the legal line ought to be, right? We ought to all accept that, words can be hurtful, but they can't actually hurt you in the way that violence can. So it's only when we're getting close to inciting actual imminent violence that we should be limiting speech. So I'm glad that you're doing this. I think kids can understand these concepts more than we give them credit for, and I'm really happy that we're getting them young, Christine. So that's all I want to say about that. Why don't we take a break, and when we come back, Joanna, you can give us your news headline. Tell us about your debate.
Okay, so on Sunday evening, I did a debate with Counselor Brad Bradford, who I guess Josh knew this. I only just learned this. His actual name is Bradford, and that is because Bradford was his mother's maiden name, so she decided to give it to him as a first name. And then when his parents split up, his mother reverted to her maiden name, and so did he. So yeah, he's Bradford, or Bradford Brad. Anyways, we did a debate for CJ on Toronto's new bubble zone bylaw. And so I'm going to talk about that a little bit and then talk about we don't have the full details yet, but we have heard some expected outlines of the federal government's expected bubble zone and anti-hate legislation, which interestingly takes a very different approach. So Brad and I were on opposite sides of this issue. He has been a champion of bubble zones. And as listeners of the podcast will know, we oppose them. But I want to say up front, I think he's a principled and very committed ally to the Toronto Jewish community. He obviously really cares about our safety and dignity. And it matters that we have municipal leaders that show up for us, even when it clearly is not easy or popular. So we disagreed on the mechanism by which to address the growing anti-Jew hate and anti-Semitism in this city, but we shared the same moral concerns. So what I said at the CJ was that Toronto's bubble zone bylaw, just to recap, creates 50-meter protest-free zones around places of worship, schools, and daycares triggered by an owner's request. And it doesn't just stop people from accessing these spaces, which they already are legally guaranteed to do. It bans acts of discouragement, which could mean signs, chants, speeches, even silent vigils, if they're seen as discouraging people from entering, which is content-based censorship and constitutionally dangerous. Section 2B of the Charter protects expression, and the government can regulate time, place, and manner, like noise and decibels, as well as, of course, access, but it can't regulate meaning. And this isn't just theoretical to me. I live near Yonge and Bloor. I watch on a daily basis intimidating, aggressive protests unfold while the police just sit on their hands. And my opinion is that my observation is that the issue isn't that we lack laws. It's that for some reason that we really need to get to the bottom of, we're not enforcing the laws that we already have. Mischief, criminal harassment, intimidation, uttering threats. And bubble zones don't solve that enforcement gap, which Bradford seemed to agree with. They just shrink the democratic square. And history shows that when you build censorship for special groups, for Jews, it will eventually be used against us when the politics shift. So that was the crux of my argument. And Bradford, he made the case. I think his most compelling case was that the police are a bit confused and they have a lack of clarity, which, again, I would say there are other ways and more direct ways to deal with that. But he did keep falling back to, this is about access. This is about protecting intimidation. And people who defend bubble zones, they can't stop but get back to that, because that's the problem that they think that they're fixing, but it's not. Okay, so we've heard enough about this. Let's fast forward to this week. Mark Carney's government is apparently preparing, which we've heard about this for a while, new legislation responding to the rise in hate crimes across the country, especially anti-Semitic crimes, since October 7th, 2023. And from what has been reported, and again, we haven't seen the text of the bill yet, it would do three main things. First, it would create a new intimidation offense, criminalizing trying to scare people away from entering religious or cultural buildings. Second, it would create a new obstruction offense, which would criminalize blocking or impeding access to those spaces. And third, it would create a standalone hate crime offense. So if someone commits another crime and it's motivated by hate, prosecutors can charge the hate element separately. Now, this is very different from the Toronto's bubble zone bylaw. Unsurprising, because Toronto can't jurisdictionally create new criminal laws. But this law doesn't ban protests by geography. It doesn't let private owners trigger a 1-year censorship cordon. It doesn't criminalize opinions or discouragement. It focuses on conduct, not content. And that is how criminal law is supposed to work. Interestingly, it revisits, this may have sounded familiar to you, it revisits the hate crime concept from the Online Harms Bill, Bill C-63, but it removes, notably, the possibility of life imprisonment. And arguably, and again, we haven't seen the bill, but we've heard it's tightening the definition of hate, which may or may not address many of the concerns civil libertarians raised at the time. We'll see. So to be clear, the intimidation offense is redundant. We already have offenses like uttering threats, criminal harassment, and intimidation under Section 423 of the code. But that's kind of a weak sauce argument. If indeed creating a specific offense tied to this pattern of conduct helps cops and prosecutors actually act on hate-motivated incidents at the doorstep of a synagogue or a church or a mosque, I'm open to considering it. But it should be underscored that what will matter most is enforcement. Laws don't protect people if they're just left to gather dust on paper. So for me, this is the critical distinction. The Toronto bubble zone model is based on, and we've seen this also with the Calgary Safe and Inclusive Access bylaw and the Vaughan bubble zone bylaw, based on banning speech based on messages and handing out vetoes over public space. But the Carney proposal, so far from what we can tell, is about criminalizing harmful conduct, intimidation, obstruction, violence. And that's something that the criminal law is actually designed to do. So it's encouraging that clearly the Liberal government and Sean Fraser have gotten the message. And in interviews, Fraser has said, you know, we can't just ban people. We can't ban lawful speech based on the location, but we can target conduct. So we certainly are very interested to see the full bill. We're holding our breath. But that is my commentary so far. What do you think, Josh?
I think if the federal bill is how they're selling it, the separate hate speech provision aside, because that might be problematic for ways we've talked about before, but if their federal bubble zone bylaw really does just ban intimidation and obstruction, which is not a content-based restriction, then I think we can celebrate because, we've been out there speaking out about bubble zones for the past year. We've been trying to explain to people that under our Constitution, you should not be able to make content-based restrictions. You should not let the government decide which ideas are lawful and which ideas are beyond the pale. I mean, the Supreme Court has messed that up and allowed some content-based restrictions that we disagree with. So you might not be able to rely on the courts, but as a society, we should be able to agree that no ideas should be illegal, that it should be only where there's imminent physical consequences or there's a form of expression that is harmful in some way, that can be outlawed, but that the ideas are always fair game, no matter how odious somebody thinks they may be, because over time, that's how we get to the truth of things. So if this is what the federal legislation actually says, and the devil is always in the details, then I'd say this is a big win for us. Christine, what do you think? You're the bubble queen, or but the
The
bubble
bubble
zone
queen.
expert, the
No, I
bubble
want
zone queen. It's hard to say.
I want to be the bubble queen. Um, like Glinda, arrive in my bubble. Um, yeah, so I think we have to wait and see the actual text of the proposed federal bubble zone law based on the reporting. It could obviously have been a lot worse. I'm a lot less concerned about prohibiting conduct that is already illegal. I mean, the criticism would be, this is a redundant law and you don't need to make new laws. You need to enforce the laws that you already have. Um, that's true, but when the alternative was the feds potentially creating a content-based restriction, this is much preferable. And I actually wonder if the feds had done this, a prohibition on conduct like intimidation and blockading access, if they had done that sooner, if the cities that have implemented content-based restrictions might have said, "Oh, well, these laws, we don't need them because the feds have this new criminal prohibition," and that would have been preferable to the clearly unconstitutional laws that we are dealing with in these municipalities like Calgary. So the Calgary bubble zone law, we did get a decision in half of it. We had done a judicial review as well as a charter claim that it was unconstitutional under freedom of expression under the charter, as well as being unreasonable. Only the judicial review portion of the reasonableness of the law, which is a very deferential standard, was heard. This February, we got the decision that we were not successful, but the charter challenge is proceeding in another forum that we're involved in. So we still have the majority of the argument to make in the challenge to the Calgary bubble zone law that's still coming. We don't have a date for that yet, but we're working with the many council who are involved in that challenge in Calgary. So more news coming on that. But maybe the city in Calgary will say we don't need this safe and inclusive bylaw anymore if the feds create the prohibition on blockading and intimidation. But yeah, that's our news about that. Sort of just in part. I will turn now to my bad legal take, which I'm going to give to American U.S. Attorney General Pam Bondi, who seems to have forgotten what country she is in because she's proposing becoming like Canada and banning hate speech, which is protected under the U.S. First Amendment. And there's a lot of case law about that. So Pam Bondi, 2 days ago, I think, went on a podcast where she talked about some of the horrific comments that some people on America's left have made, sort of justifying or celebrating the assassination and brutal murder of Charlie Kirk. Obviously, those comments are disgusting, and we should, as a society, condemn them. But Bondi suggested that they might be hate speech. And she said, there's free speech and then there's hate speech. And we will obviously target you, go after you if you are targeting anyone with hate speech. I actually don't think that those comments would even be hate speech under Canada's um, hate speech prohibitions, our criminal prohibitions on hate speech. They wouldn't, from what I've seen, even be in that category. And sort of the horrible irony of Pam. I mean, she's been lambasted for this by conservatives in the United States, saying, "What are you talking about?" She sort of walked back the statement. America apparently doesn't want to become like Canada. And I would just note that there's a horrible irony in her suggestion, given that Kirk was such a steadfast opponent of censorship and specifically hate speech prohibitions. He said, I think about a year ago, hate speech does not exist legally in America. There is ugly speech, there's gross speech, there's evil speech, which all of these things people have been saying about Kirk, I think, fall in those categories. But he said all of it is protected by the First Amendment, revealing that he had a much better understanding of America's constitutional protections for free speech than the country's current attorney general, who I guess wants to move to Canada. I don't know.
I think I'll give my bad legal take now because it's closely related to this, Christine. It's just we shouldn't be surprised, but those comments by her were a turning point, and these turning points happen every time there's a new government eventually, because when people are in the minority, when they're in opposition, when they're not the people in power, they're always saying, I need free speech, I understand free speech, I respect free speech. And then as soon as they're in power, or at least, eventually while they're in power, they always turn on free speech. It's so funny how that happens. In 2022, it's the truckers who are saying we need free speech, protect our free speech. And so it's, a right-wing coded issue, and the left is kind of rolling their eyes saying, oh, that's not really free speech, that's hate speech, and we should be able to shut you down. And then, in 2024, it's the pro-Palestinians of the left saying, hey, stop trying to shut down our speech. And that brings me to my bad legal take. So this is from someone named Ralph C. on X, and there's a professor, her name is Dr. Ruth Marshall, on Twitter. She's a U of T professor who's been one of the most awful people during the whole post-October 7th era. And in the wake of the Charlie Kirk shooting, she wrote on X, shooting is honestly too good for so many of you fascist see you next Tuesdays. And then Ralph tweets to this, and he gets several thousand likes on this tweet. To whom it may concern, at Toronto Police and RCMP, I'd like to file criminal hate crime charges against Dr. Ruth Marshall, faculty at U of T, under sections 318, 319, and 329 of the Criminal Code. So what she said is reprehensible. It's awful. She's been removed from her position, at least temporarily, at U of T. And I think, considering how dangerous and how close that comes to an actual threat, I'm not surprised that U of T has taken that action. But this is not even close to a criminal hate speech crime, even under our law, which permits going to jail for mere speech. This is not the most extreme forms of the most extreme manifestations of detestation and vilification. There's no particular minority group here. This is done online instead of in public. It has nothing to do with genocide, which is what Section 318 is. So, people need to stop doing this. They need to stop saying every time they see comments on social media that they don't like, that they need to have the police intervene and lay hate crime charges, because even in Canada, where we have hate speech criminal laws, that doesn't come even close to the legal standards. So bad legal take to Ralph C. Joanna, let's hear yours.
Okay, my bad legal take goes to Mr. Bradford, who I mentioned is a good guy, but he's not a lawyer, and it showed. So during the CJ PAC debate, when I laid out the constitutional problems with Toronto's bubble zone bylaw, the fact that it's content-based, etc., Councillor Bradford's legal argument led with, well, no charter right is absolute. Section 1 says rights can be limited if it's reasonable, which is, of course, technically true, but also kind of like the Uno reverse card of bad legal takes, because yes, Section 1 of the Charter allows governments to limit rights if they can pass the Oakes test, show the limit is prescribed by law for a pressing objective, minimally impairing, and proportionate overall. But you don't just wave Section 1 around like bug spray. You have to actually particularize your response and show that your law meets the test. And content-based restrictions on speech, political expression especially, face the highest level of scrutiny from the courts. And the Supreme Court has said that they are presumptively unconstitutional. And the Toronto bylaw is vague, overbroad, owner triggered, applies to over 3,600 public facing sites. The city's own solicitor admitted they couldn't guarantee it would survive charter scrutiny. And I think, if I may, if Councillor Bradford wanted to make a serious charter defense, the stronger route would have been a practical necessity argument. That would be, showing the ends are proportionate, the means are proportionate to the ends. He would say something like, police lack clear operational tools and enforcement has been inconsistent. So this is the only way to actually ensure safe access in real time. Of course, this wouldn't make it constitutionally flawless, but it would be an actual Oakes justification argument, tying the infringement to a concrete enforcement gap, instead of just saying, well, no right is absolute and calling it a day. So yes, Section 1 exists, but it's not a cheat code. You don't get to just pass go and collect censorship just because you claim reasonable limits.
Yeah, good one, Joanna. As you mentioned, I was at the debate in the audience, and I just want to say it was a good reminder that more teachers and parents should check out our high school course backs where we teach all about how the Constitution works in civics, because even our legislators don't always know the basics of how this stuff works. So that's the end of the show. Thank you, as always, for listening, for rating us on Apple Podcasts if you haven't already, for subscribing, for telling your friends about this podcast. The CCF is a non-partisan legal charity funded by your donations, so please do go to our website and donate if you can. Thanks for listening.